السلام عليكم ورحمة الله وبركاته. بسم الله الرحمن الرحيم. نحمده ونصلي ونسلم على رسوله الكريم. أما بعد, and welcome to another video on the Islamic Knowledge YouTube channel. And in this week's video, we're looking at a very relevant book for our times. With the Syrian new government currently being formed, I thought it would be timely to speak about this incredible book titled Islamic Law and the State, the Constitutional Jurisprudence of Shihabuddin al-Qarafi by the American scholar Sherman. So this book, by the way, is published by Brill, and it's actually a 229-page book in terms of reading, and the original looks a bit like this, but seeing as it costs a huge amount on Amazon, if you have a look, I decided to publish it with DocZoo, and this isn't a paid promotion, by the way. I've just benefited from their printing, so I got mine printed with them, and I will put a PDF of the book and my notes. So I've even got some notes that I've made of the book, as you can see here. You could see it's like an A4 version of the notes here, and I will put a PDF of the entire book itself and my notes on the Islamic Knowledge Telegram channel. So if you just go on to Telegram and you type in, as you can see in the center of the screen, if you just type in @IK Courses, you should be able to find the PDF of the book. You'll be able to see the Telegram channel that will turn up, and you will find a PDF and of the book and of my notes inside the Telegram channel. So what's this book all about? As you can see, the book has 6 chapters, and they're nicely presented with some sub-chapters as well. So you can see here, we've got the first chapter is on Shihabuddin al-Qarafi, his CV, so to speak. Then we've got chapter 2 on the Egyptian context. Then chapter 3 on the Madhab, al-Qarafi's constitutional unit. And then chapter 4, the limits of law against the tyranny of the Madhab. Then we've got chapter 5, the judiciary and conflict of laws. Then we've got chapter 6, defining the legal jurisdiction of the state. And this book is basically a study of the 7th century Egyptian Maliki scholar al-Qarafi, who was born in 626 Hijri and passed away in 684 Hijri at the age of approximately 58. As you can tell by the dates, al-Qarafi was living in Ayyubid Egypt and then later Mamluk Egypt, and of course he was a contemporary to the Mongol invasion of Baghdad. And so this book can be thought of as a study of Mamluk intellectual history and al-Qarafi's views of how the government should be run, and one particular issue that he wanted to address, which we're going to come to just now. And so al-Qarafi outlines his view in this Arabic book titled Al-Ihkam fi Tamyiz al-Fatawa an al-Ahkam, which has actually been printed with the footnotes of Sheikh Abdul Fattah Abu Ghudda, as you can see. And it's not really so many footnotes, but it's more i'tina, so to speak, or just printing the book, which is what Sheikh Abdul Fattah has done. But he's got a nice introduction to the book. And this English book is basically a study of this Arabic book, and it's an absolutely incredible study. The first chapter covers an introduction to al-Qarafi himself. So we're basically looking at the CV of al-Qarafi, as he said in chapter 1, and that's where it kind of gets really, really interesting. And in that introduction itself and the life of al-Qarafi, you learn so much about the actual context within the Ayyubids and the Mamluks themselves. And a very decent introduction, by the way, on Islamic law and books written on Islamic political theory to a large degree. And then on page 1 here, he literally starts off with a discussion on al-Qarafi. And there's an interesting story of how actually al-Qarafi earned the title al-Qarafi itself. So he says his sobriquet, al-Qarafi, reportedly attached to him during his youth. Frustrated by his failed attempts to recall his proper name, a roll caller at a schoolhouse simply decided to write al-Qarafi. And after noticing that the youth used to approach the premises from the direction of al-Qarafa, so we don't know if that's 100% true, but it's just an interesting way as to how he got the title al-Qarafi. Then on page 2, so my book is printed in this way, but if you've got the original book, it should be printed in normal manner. On page 2, we learn that al-Qarafi became the leader of the Maliki school in his time. So the author actually mentions here on page 2, he says, during his lifetime, however, al-Qarafi was hailed as one of the greatest scholars of his day. Leadership of the Maliki school in Cairo is said to have devolved upon him. انتهت إليه رئاسة الفقه المذهب المالكي, and according to the testimony of the Maliki chief Judge Taqiyuddin ibn Shukr, the Malikis and Shafis all agreed that the greatest contemporary scholars in Egypt were 3: al-Qarafi in Old Cairo, Nasiruddin ibn al-Munayyir in Alexandria, and Taqiyuddin ibn Daqiq al-Eid in Fatimid Cairo. On page 3, we learn that al-Qarafi actually knew Hebrew. So the author says here, in his Al-Ajubatul Fakhira an As'ilatil Fajira, a refutation of certain Jewish but especially Christian charges, he flaunts his knowledge of Hebrew, quoting and translating the Old Testament in Arabic script. Meanwhile, Brockman cites Ghurb al-Fakhira raddan ala millat al-kafira as the greatest apologetic achieved in Islam. Even in this introduction by Sheikh Abdul Fattah Abu Ghudda on al-Qarafi as well, he mentions how al-Qarafi had literally made a robot for himself, and he was really into inventions to wake him up for Fajr and to kind of do different things for him. It's really, really interesting. He seems to have been a bit of a polymath, so to speak. On page 4, we're still in chapter 1 and we're still learning all about Al-Qarafi. He mentions how Al-Qarafi's only Maliki competition was in Egypt was actually Ibn al-Hajib. So the author says on page 4, this is not to deny, however, that assuming that the biographical dictionaries of Ibn Farhun and At-Timbukti suffer no serious omissions, he was probably the greatest Maliki legal theoretician in all of 7th or 13th century Egypt. His only competition in this regard being the Kurdish repatriate from Damascus, Jamal ad-Din ibn al-Hajib. And this is another unique feature of the book, by the way, that you will constantly see the Islamic date being presented and then followed straight away with the Gregorian dates right with it, which is really, really beneficial. On page 9, the author discusses that although Al-Qarafi had many teachers, his most prominent teacher was actually Izzuddin ibn Abdis Salam. So he mentions on page 9 here, by far, however, Al-Qarafi's most important teacher was the redoubtable Shafi'i jurist Abdul Aziz ibn Abdis Salam ibn Abu al-Qasim ibn Hassan ibn Muhadhab, better known as Al-Izz ibn Abdis Salam. Even before he came to Cairo from Damascus in 1241, Ibn Abdis Salam's reputation had become the stuff of legend. And then there's a story on page 10 that speaks on the audacity of Izzuddin ibn Abdis Salam, which is that when he received a word about a certain house of ill repute that had been allowed to operate unmolested by the authorities, he marched up to the citadel. This is Izzuddin ibn Abdis Salam, this is not Al-Qarafi, this is his teacher. When he marched up to the citadel and gave the Sultan a royal reprimand, when the Sultan explained that he was not responsible for the situation and that he had inherited it from his father's reign, Ibn Abdus Salam reportedly asked if he would be content with being among those condemned in the Quran who say, we found our fathers following a way and we are following their example. So you can see his ruthlessness and his audacity. In fact, on page 11, there's a quote here that when Izzuddin ibn Abdus Salam passed away, Baybaras was actually very happy, well, not happy, but he was content that now my kingdom is secure. When Ibn Abdus Salam finally died, Baybaras is reported to have breathed a sigh of relief, saying, now my reign is secure, for were this sheikh to incite the people against me, my kingdom would be snatched away. Now I want to quickly draw attention to how the author is unique in that he tends to quote original Arabic sources, and it's sad to say this, that it's not very common to see an author regularly quoting original Arabic sources, especially when we read Western academia. But if you look here, just on page 10, if I were to just look at the footnotes here, he's already quoting so many books that are in Arabic that it really is quite impressive. And it's very rare to see this in our Western academia. It's not very often. He's quoting Bada'i'. This is not Bada'i' al-Sana'i. This is a book on Egyptian history, so to speak. Shadarat al-Dhahab. He's quoting Husn al-Muhadara of Hafiz al-Suyuti. He's quoting Fatawa Sultan al-Ulama Izzuddin ibn Abdus Salam. He's quoting Qawa'id al-Ahkam of Izzuddin. He's quoting the Fatawa again. He's going back to the original Arabic sources, showing that he's adept. He understands Arabic. You can see almost every single reference is to Arabic books. And it's, like I said, if it wasn't for the fact that this isn't a very common thing to notice, then I wouldn't have mentioned it, but it is not very common. Kitab al-Intisar liwasitat Aqd al-Amsar al-Wafi. Maqrizi's khitat is being quoted quite extensively throughout the book. So these books written on Egyptian history, on, you could say, Syrian history, he quotes them right from the original source. Now on page 21, the author has an interesting section on the Ash'arism of Al-Qarafi, which runs until the end of page 32, which is over 10 sides, and they're actually quite interesting. So you got all the way from here, Al-Qarafi's Ash'arism, and there's a really detailed discussion on it, and we learn basically that Al-Qarafi was as Ash'ari as it gets. And then chapter 2 begins, and chapter 2 is, I believe, genuinely a must read for every student of Islamic knowledge. If you know anything about Islamic history, you'll know that the Mamluks had an incredible impact when it came to scholarly developments, and they were a means of the rejuvenation of so many fields of Islamic knowledge due to the empowerment they gave to the ulama. And you could say they needed credibility from the ulama, and so they gave that credibility to the ulama in order for the ulama to recognize them as well. And it's more to do with, you could say, authority for the Mamluks. They lack that authority, knowing their background, that they come from slavery, etc. So this chapter speaks about the tumultuous period when the Mongols were heading towards the Western Muslim world, while the various Ayyubid princes were squabbling amongst themselves. For example, the author explains how Al-Qarafi lived through 12 rulers, as he says on page 35. Ayyubids and Mamluks chaos and innovation, the cycle of Cairo's precarious rise. And then here, these are all the Ayyubids, and these are the Mamluks that Al-Qarafi had to live through. So this many people in just an age of, you could say, he only lived for about 58 or so years. And to think that in 58 years, these were the different leaders that came into power just speaks about how tumultuous that period was in Egypt and Syria at large as well. So Al-Qarafi's relatively short period, he says here, the author writes that, and it is in this period that Al-Qarafi sees through his early 20s into his early 30s and intellectual maturity. There would seem to be little doubt about its impact on him as a thinker, especially when one considers his preoccupation with issues of power and the limits of government. The following are the Ayyubid and Mamluk regimes through which he lived. Then the author speaks of the two most influential rulers in Egypt during this period, who are As-Salih Ayyub. So it's this one here, As-Salih Ayyub. He was very, very influential in Ayyubid Egypt, who was the grandson of the brother of Salahuddin, who created what, as the author speaks about on page 40, the Salihiyya Madrasa. So the Salihiyya Madrasa, which was a very, very unique madrasa. So he speaks about this madrasa here, As-Salihiyya, and the madrasa was the first of its kind ever in Egypt, holding as it did a chair for each of the 4 Sunni schools of law. It was apparently modelled on the Caliph Al-Muntasir's Mustansiriyya in Baghdad, though it is difficult to tell whether As-Salih's action implied flattery or defiance. At any rate, from the time the Salihiyya began operating in 641, it exercised a profound and permanent effect on the political situation in Cairo. For in an unprecedented fashion, this madrasa brought all the Sunni schools together in an open competition when each could argue the superiority of its position regardless of its political standing at large. So the reason why this is quite important is that up until this point in the early Ayyubid period and even throughout the early Mamluk period, the Shafis had you could say a type of monopoly wherein all the chief qadis, or there was only one chief qadi, and all of the main rulers or the main playmakers in these empires were the Shafi'is. And finally, the second influential leader is spoken about from page 49 onwards, and that's Al-Zahir Baybars. And he's got a lengthy discussion on Baybars here on page 49, and he speaks about him in detail. And that's Al-Zahir Baybars, during whose rule Al-Qarafi wrote Al-Ihkam. So Al-Ihkam was actually written during the rule of Al-Zahir Baybars, and on page 64 the author speaks about what the actual issue was. So what was happening and why did Al-Qarafi actually write his book Al-Ihkam? And it's a really, really interesting incident, and it explains the kind of, you could say, monopoly that the Shafi'is had up until Al-Zahir Baybars created his reform policies. So on page 64 the author speaks about the issue, and essentially what was happening was that the chief qadi, so it was Shafi'i exclusivism in the judiciary, and a closer look at that, and basically to explain what was going on. The chief qadi in Egypt was a Shafi'i by the name of Ibn Bint al-A'az, and he was another student of Izzuddin ibn Abd al-Salam and was quite literally his protege, so to speak. And he was doing something quite ruthless when you think about it, which is whenever a Hanafi or Hanbali or Maliki, and remember he was the chief qadi, he's the qadi al-Qudat, he's the main judge, whenever the other madhahib, the judges from the other madhahib provide a ruling, what this chief judge would do was that it would technically be his responsibility to register the ruling, but he would just not register it, and he would do something which we refer to as tawaqquf. He just would stay behind from registering, and that would actually lead to the ruling not having any effect. It wouldn't be considered as part of the law. So you could give a ruling in regards to a case between a husband and a wife, but because you're not a Shafi'i, the Shafi'i chief judge is not going to register the ruling, and nothing will actually even take effect. So the author says on page 65, and he explains exactly what was going on. As the Sultan's direct representative, the chief judge was the principal of all other judges on the circuit. By refusing therefore to register rulings, he could block the enforcement of any lower court decision with which he disagreed. This was the essence of stopping short, tawaqquf, mechanism resorted to by Ibn Bint al-A'az. So it is a form of ta'assub, you could say, and it's because of this that Al-Qarafi wrote his book Al-Ihkam, arguing that the ruling given by the Qadi, it's not his ruling, but rather it's the ruling of his madhab, which is basically a corporate entity. So each Qadi is not giving his own ruling, he is protected by his madhab, which is the understanding of a generation of scholars up until this period. So you are not rejecting the ruling of this person, this Qadi, he's speaking to the chief judge here, you're not rejecting the ruling of the chief of the qadi here, you're actually rejecting the ruling of a madhab, and it's a corporate entity. And that's the key idea here, which is that he's treating the madhab as a corporate entity, which is kind of made up of loads of people working together. And it's not just a fatwa that's being given in the legal judicial ruling, it's actually a hukam, and you can't dispute it. So Qarafi makes a distinction between a fatwa and a hukam, and as long as the situation is found wherein within his madhab is ascertained to be the reality in the case itself, you can't actually reject it. The author gives a brilliant example explaining Al-Qarafi's solution on page 151. So if we jump right ahead, it kind of explains exactly what Al-Qarafi is trying to say. He's saying that in fatwa we can dispute with one another, but once it becomes a legal ruling by a judge, you can't dispute it anymore. And this is given through a brilliant example by the author. He says, now two men, a husband and a father-in-law, both tattered and salih, enter the Salihiyya madrasa in pursuit of a fatwa concerning the case of the man's wife, the father-in-law's daughter, who is threatening to seek an annulment. Upon their entry, they find two muftis seated, engaged in a discussion. They approach the two, the husband states his case, and they await a response. Before responding, the first mufti inquires about the man's financial state. Pardon me for saying so, but you appear to be of that class of people whose periodic inability to support their spouse is known and perhaps expected. Have you of a sudden fallen upon bad times, or is this your normal and apparent state? The man says, I am a poor tiller of farmland, replies the man. Whenever there is land to till, we work and earn our living. When there is not, God is our only provider. He then asks, and your wife knew of this at the time of your marriage, did she? Yes, replies the man, and as does everyone else. Then go in peace and do not worry, the mufti advises him. Under such circumstances, your wife has no right to annulment on grounds of your temporary inability to support her. But then the husband happily departs, at which time the father-in-law exclaims in a frenzy, but we are migrating north and this man cannot support my daughter. From where is she to survive? Exactly, interrupts the second mufti. And it is for this reason the lawgiver has legislated the ruling to the right to annulment under such circumstances, regardless of the husband's financial state and at the time of the marriage. Gather your witnesses and have your daughter present her case at court, for the law of God provides amply for such circumstances this marriage is to be annulled. The father-in-law departs. Upon his exit, the Shafi'i and Maliki muftis plunge into a heated debate over the case of the two men and the propriety of the fatwas they receive. Finally, the Maliki mufti exclaims, I am aware of the Shafi'i position, as I am aware of the merits of the argument adduced in support of their view, but I am the judge in this district by appointment of the Chief Justice, and I subscribe to the Maliki view on this question. If this woman brings her case before me and her husband provides ample proof of her knowledge of his indigence at the time they married, I shall flatly deny her petition and uphold their marital bond. So the Maliki mufti was the first mufti and the Shafi'i mufti was the second one. Now Al-Qarafi's point is that the action of the Shafi'i mufti at the Salihiyya was legitimate. You can argue, that's fine in fatwa. For the first statement by the Maliki mufti was a fatwa. As such, its state was not affected by the Shafi'i's espousal of his own view. But in the second instance, after the case has been tried, the Shafi'i mufti erred and in doing so violated consensus. For the second statement of the Maliki as a judge was not a fatwa but a hukam. It was thus illegal for the Shafi'i to challenge this view in any way, as it would be illegal for the Chief Justice to overturn it subsequently. So there's a difference between a fatwa and a hukam, and that's the whole reason behind the title of this book, Al-Ihkam fi Tamyiz al-Fatawa an al-Ahkam. And by the way, it was the actions of this chief Shafi'i judge, Ibn Bint al-A'az, that led Baybaras to make his judicial reforms, wherein he appointed a chief qadi for every madhab. So there wasn't just one chief qadi, the Shafi'i chief qadi. There were 4 chief qadis. In any case, chapter 3 begins from page 69. Just to go back to where we were. So page 69 is where now essentially you could say that chapter 3 now begins, and this is where it's a really interesting discussion about what is a madhab and how an actual madhab works according to Al-Qarafi. And this is where he speaks about the conception of Al-Qarafi's idea of a madhab and how that is what is essentially supporting the Qadi's ruling. As around Al-Qarafi's time, there had been a sort of agreement that it was no longer required for a Qadi to be a mujtahid. Rather, a judge is required to rule in accordance to his madhab. So the author mentions on page 78, one of the clearest indications of the gradual ascendancy of taqlid emerges when one reviews descriptions of the judicial function before and after the 6th century. It should be noted is particularly instructive in this regard, in that despite the perduring controversy over whether muftis could base their response on taqleed. Prior to the 6th century, there appears to be universal agreement that judges had to be mujtahids, capable of deducing the law independent from scripture. That's before 6th century. By 6th century, however, this requirement appears to fade, and this development is reflected in subsequent manuals on Adab al-Qadi, basically, whose intended design undergoes a fundamental change. And then he goes through all the Adab al-Qadi books, and he explains how before 6th century we notice the requirement for ijtihad, and after the 6th century we notice there's a lack of requirement. And then on page 116, the author discusses how Al-Qarafi actually comes up with the 5 constituents of a madhab. So that's on page 114, he discusses the 5 constituents, and then on page 116 he discusses how Al-Qarafi limits how a madhab could be used to abuse the law itself, and that's on page 116. So firstly, on page 114, well, just to look at page 16, he will kind of cover it anyway. In his response, he says, according to him, basically according to Al-Qarafi, the madhab is limited to how much you can use it. According to him, the madhab of an imam is limited to those constituents mentioned above, namely the legal rules which make up the branches of positive law and have been deduced on the basis of ijtihad. Number 2, the legal cases, asbab, what activates rulings. Number 3, the legal prerequisites, so shurut. Number 4, the legal impediments. And number 5, the hujaj, the evidences. So this is really, really important. And the book then carries on with chapter 5, speaking more about the Ibn Bint al-A'az issue, and then chapter 6 rounding everything off by speaking about the role of the statements of the government and what the government does in all of this. Now, in terms of the unique discussions of the book, then by far one of the most interesting aspects of the book is whether this author speaks about what is proper taqleed and what is improper taqleed. And we have a chapter on this, by the way, on page 123. It's called the limits of corporate protection, proper versus improper taqleed. And this is a really, really interesting section. In this section, Al-Qarafi explains that we follow the madhab in its legal ruling, but not in its determination of the facts. So the author says on page 125, and this is a really, really interesting discussion, this distinction between law and fact, or between the status of things and the actual occurrence, has important implications for taqleed. For according to Al-Qarafi, not only are muqallids restricted in following their imams to the 5 constituents of madhab, they are also restricted to following the latter in what they say concerning the status of a thing as a constituent of madhab, in contradistinction to what is said concerning the actual occurrence of this thing. This becomes extremely significant when one considers the fact that much of what is handed down on the authority of the imams and ancient authorities contains an admixture of scriptural interpretations and assessments of facts to which these interpretations were applied. This raises the danger on the part of muqallids of confusing law with fact. So we follow the imam in law, we don't follow him in fact, and of accepting as authoritative everything that has been handed down. This practice of confusing law with fact is condemned by Al-Qarafi as constituting or leading to improper exercise of taqleed. For example, Imam Malik may have a ruling of what is the ruling of any city that has been conquered through, you could say, force, and then he says Egypt is like that. So we can follow him on the first thing, but we don't follow him on the second thing. The first thing, he's giving a ruling that any country that has been conquered by force, then it will be of such a nature, and then he's applying that ruling to Egypt. We don't need to follow him in the application, we need to follow him in the rule that he's come up with. And Al-Qarafi explains that in really, really interesting ways. Another interesting comment in the book is where the author mentions on actually page 8 on how Fakhruddin al-Razi rahimahullah's Al-Mahsul may have been a more important book than some of the other books that have come as well. We have 4 important books, as we know, in the Manhaj al-Mutakallimin, if we accept those type of distinctions. But nonetheless, if we do, we have Imam Fakhruddin al-Razi's summary of all 4 books and kind of like adding that he did to the Manhaj al-Mutakallimin books in Usul Fiqh. But it seems like his book was the most important, Al-Razi's, more than even Al-Juwayni and Al-Ghazali's. But this may be a result of our failure to appreciate the significance of Al-Razi in later, i.e. post-7th century Usul Fiqh overall. From the comment by Al-Isnawi, for example, on Al-Baydawi's widely read Minhaj al-Wusul ila Ilm al-Usul, we learn that Al-Razi was viewed as something of a master synthesizer who had successfully digested and integrated all that had preceded him. And then he speaks more about Al-Razi. Another interesting discussion is where Al-Qarafi discusses a concept concept that is both important in the Maliki school as well as in the Hanafi school, which is the Qawaid Kulliya of Sharia as understood by the Imam of a madhab. So in order to extract a ruling in accordance with the madhab of an Imam, which is called takhrij, you extract a new ruling that has not been mentioned by the Imam. You not only need to know usul al-fiqh, but you also need to know the qawaid of the Imam, which is beyond usul al-fiqh. So he writes on page 92, and this is basically him explaining the importance of the qawaid idea in the Maliki madhab. He says, thus according to Al-Qarafi, it is not permissible for a jurisconsult to extrapolate a ruling for an unprecedented question unless he is thoroughly capable of recalling the legal precepts, qawaid of his madhab, along with the rules of consensus. And to the extent that he is deficient in this ability, it is prohibited for him to perform takhrij. Nay, under such circumstances, he should respond only to questions already treated. Another interesting point, especially in today's context, is what the author says on page 70, which is that scholars like Ibn Taymiyyah and Al-Qarafi were less concerned with how a ruler came to power, but more with how they were actually ruling. And that was everything that defined for them a good ruler or a good state from a bad state, so to speak. And that was everything for them. So he says on page 70 that Al-Qarafi should concern himself with matters of government might appear at first blush to contradict the widely touted notion that medieval jurists were generally passive in their attitude towards power and the activities of the state. It is important, however, in attempting to assess Al-Qarafi in this regard, to understand the precise nature of the political passivity in question. It had already been noted that no less a figure than the redoubtable Ibn Taymiyyah could, on the one hand, argue fervently in favor of the rule of law, while at the same time showing virtually no concern whatever for such issues as whether the Imam came to power legally or illegal or through illegal means. This was based on the fact that, as E.I.J. Rosenthal has observed, Ibn Taymiyyah's center of attention was not the caliphate or power at the top, but rather the larger community and its relationship to the sacred law. And he discusses this further in detail. And this is absolutely an amazing read. Amazing book. I really enjoyed it. With everything that's happening in Syria right now as well, I thought this was a very timely book to read, and it portrays some of the challenges that scholars of the earlier periods were facing with their engagement with the political state. I highly recommend this book for every scholar. I hope you enjoyed this video, and please do share it with others, and I hope to see you on the next one. Jazakumullahu khair wa ahsan jaza. Wassalamu alaikum wa rahmatullahi wa barakatuh.